Next is Justine Kelly, followed by Peter Nasita. And again, if you didn't hear me, apologize already. I'm really bad with pronouncing names. So.
Good afternoon.
Thank you.
My name is Justine Rakich Kelly, and I'm the Executive Director of the Children's Law Center of Connecticut. And I have submitted written testimony. I'm not going to read it. I'm not even really going to refer to it too much. I'm just going to highlight a few things for you. First, let me tell you a little bit about the Children's Law Center for those of you who don't know who we are. We're an organization, a nonprofit organization that provides guardian ad litem and attorney for the minor child services to indigent children in the family court system. That's what we do. And in our cases, the children are in families of indigents, so their parents cannot afford counsel, cannot afford to pay a guardian ad litem. And in all of our cases, there are exacerbating issues such as mental illness, drug or alcohol addiction or abuse, chronic conflict between the parents, police involvement, DCF involvement. Something is occurring within the family that comes before a court that gives the court concern that the children may or may not be at risk, and that's when we're appointed. We don't accept cases where a family is of means. We only take cases of indigents. In our representation cases, the unique thing about the Children's Law Center is that we incorporate a mental health component into the work that we do. We have an on-staff mental health professional, and while our attorneys, they're legal attorneys who act as guardians ad litem, all of our cases are informed by a mental health perspective. So we have a mental health professional who meets with the parents, with the attorneys, meets with the children, and helps us to do our assessment and craft proposed orders that would really reflect what's in the best interest of the children, and also will work for the particular family. In addition to the representation program, the Children's Law Center also runs a program called the Families in Transition program. And that is a mediation program and a parenting education program where the parents are the clients. They come to the office, they meet with the gender-balanced team of experts, a lawyer and a mental health professional, to help the parents mediate their immediate disputes, but also to give them tools to learn how to co-parent and to communicate and learn how to put their children's needs and issues before their own. So when successful, the Families in Transition program is able to successfully divert a case out of the high conflict court system into the Families in Transition program, so that the only thing that goes back to court is whatever their resolution is, and the parents have figured out, have learned how to co-parent together and make decisions for their children together. I want to stress the work of the guardian ad litem and in the work that we do. As I already said, we incorporate a mental health component into our work because it's vital that we understand the emotional needs of the family. I guess I'll just end there and ask if anyone has any questions. You have my testimony.
Thank you very much. Are there any questions?
I have a question. Hi, Justine. And you testified that part of you getting appointments for guardian ad litems is that the mental health professional meets with the parents and the attorneys that are representing the parents?
No. Oftentimes the attorneys, our staff attorneys are meeting with the parents, and the mental health professional will consult with the attorney who's meeting the parents, or will actually meet with the parents together with the staff attorney to meet with the parents to ask questions and understand what the history is.
Okay, so the staff attorney from your agency?
Yes.
Okay.
We would meet with the parents opposing counsel if they requested it.
Dr. Thayer. Hi, Justine. Thank you for coming. I'm just going to disclose that I'm on the board of the Children's Law Center, so I just want to say that, so as I'm asking you. So I was wondering, the organization, as we know, has grown tremendously over the last couple of years. Right. So maybe you can speak to that plan for, because we have become almost statewide. You have become almost statewide as an organization.
Right. We have about, I want to say we have about 5 jurisdictions still to expand into before we're statewide. But the plan is for the representation program to provide services in every judicial district in the state of Connecticut, And then as that program expands, follow it with our Families in Transition program. I mean, we approach cases with the thought that both parents have a very important role to play in the lives of their children. We try to work with parents to educate them about the importance not only of their role, but of the other parents' role in the children's lives, and try to help them come to agreements that will work for the children. And we stress that in our representation program. We stress it even more in our Families in Transition program, with the hope that eventually the process will be a more collaborative process rather than the adversarial process that we work within today.
And the Families in Transition program is a volunteer program.
Yes.
Both mediators, a lawyer, and a mental health person are volunteer.
Yes.
What do you think will help that? I know there's a backlog in availability, big backlog in availability. So what's going to be helpful to make that available to not only the families you see, but more families?
Well, that's the difficult thing, that the families who want the service or who are ordered to attend the service, once they call our office, they're on a waiting list immediately. And so really we just need resources in order to have the program expand more quickly and meet the need of the families. The families that attend the FIT program, the Families in Transition program, when successful, it's a very positive thing for the families and especially for the children, and they don't have to go back to court again because they've developed the tools to be able to co-parent outside of court. They don't need to resort to court to fight battles that they no longer have. So really it's a matter of resources. I mean, we can continue to recruit volunteers and train volunteers and hope that we would have enough to meet the need, but there isn't enough to meet the need that we have.
Thank you.
And if you could just talk a little bit more about your program and what rates your attorneys are paid at and how someone qualifies for your services.
Okay, the court appoints us in a high conflict case. They make an initial determination that one or both of the parties is indigent. We also do a financial eligibility. The parties have to be below 125% of the federal poverty guidelines. We don't bill parents. Parents do not pay our services. We have a contract with the state of Connecticut to handle, I believe the number is over 400 cases, to represent over 400 children a year for a set dollar amount. So we don't get paid by the hour at all, and our attorneys aren't billed by the hour. They're staff attorneys. They're paid a standard rate regardless of their caseloads.
The amount that the state pays you, is that a state rate?
It's a state rate. I don't know if it's what the individual attorneys get for a contract. Our contract is $82,500 a quarter, and the agreement is that we will represent 440 children a year at least for that contract.
Okay, and the reason I was asking those questions is, there is a lot of talk about guardian ad litems becoming rich off of being appointed to cases, but your attorneys are
not rich. Well, I can explain this. I don't believe a private pay attorney could survive a practice on just state rate cases, or being paid at the same rate as a state rate case does. The Children's Law Center is able to do it because we're a nonprofit and we get funding from private foundations, individual donations, and we get resources by professionals volunteering to assist us. A regular private pay attorney in their own private practice doesn't have all of the other resources available to them that we do.
Thank you.
Representative Gonzalez.
Thank you. And thank you for coming.
Sure.
Your office is located at 40 Arbor Street?
30
30.
Arbor Street, yes.
Okay, 30. Sorry for that. And you said that all the cases that you get involved or they are recommended to the court, they are parents, they are indigent.
Yes.
Also, okay. Can you tell me, do you have a lot of successful cases, like where parents get along, where parents agree, where the court is happy they don't with those cases? Or
Okay, here's what I can tell you. The cases that come into us are by definition high conflict cases. The parents do not get along, they don't co-parent, they don't want the other parent to have significant time with their children. So we're starting from a place where they're not successful at that time. The cases, we do track our case closing, our outcomes at case closing. And in our cases, less than 20% of the cases that close don't reopen within our office, which tells us that if they go back to court, they're over financial issues and not custodial issues. We're not being reappointed, and we're not reopening them within our office. I can tell you that.
Okay, and do you have a lot of, knowing because the area, do you have a lot of diversity, clients, just Latinos, African American,
Yes.
what? You have a lot of
Yes, we do.
diversity?
We have 2 attorneys who are Spanish speaking. I can't tell you the demographics off the top of my head of the clients who we represent, but it's a very diverse clientele. Our office is located at 30 Arbor Street in Hartford, but we accept appointments in the courts of Hartford, New Britain, New Haven, Waterbury, Bridgeport, Stamford, Wyndham, and Rockville. So we are almost statewide, and the attorneys have offices at 30 Arbor, but they also handle cases by remote access.
Okay,
So we're in the neighborhoods where our clients are.
you in the neighborhood, the clients are receiving this type of services.
Right.
And that's my area, that's my district. And I'll be passing by because I want more information.
Okay. You're more than welcome.
It seems like the clients, they're indigent, they don't have no resources. It seems like for whatever reason, it seems like they don't have through the whole, 4 years, 5 years in court. And I believe that the reason is no money involved. So because there's no money involved, I don't think that it's a fight. It's not I think that because it's no money involved, I think that's the reason. But I will say that knowing that you're in my district, I would like to sit down with you and have a little conversation about this,
sure,
and maybe
welcome.
give a tour and check about not specific client, but I would like to know more about this.
Okay.
Okay, thank you.
You're welcome.
Mr. Gitano has a question, and then Dr. Horowitz.
Hello, how are you?
Hello. Good, thank you.
I know that you've done a lot of cases, and your agency's done a lot of cases. Can you talk a little bit about what happens in the court system as a guardian ad litem for the cases that you have, and what typically happens? I know you said that 20% don't come back in the court system. What's your experience in resolving disputes in the court system?
That's a very broad question. I'll try to answer it as succinctly as I can. The attorneys have a protocol in our office that they go through in analyzing a case. We work very closely with the parents and with the parents' attorneys, if there are attorneys for parents. In many of our cases, there are not, because they don't have the money to pay for an attorney. Although there are oftentimes legal aid attorneys that are involved in our cases. But we'll meet with the parents and with the attorneys, if any, to try to work out agreements. In many of our cases, there are hearings along the way, but generally we don't ultimately go to trial in most of our cases. And so we're able to resolve them in a somewhat successful manner prior to going to trial.
Dr. Horowitz.
Justine, hi, I'm Bob Horwitz from New Haven.
Hi, good to see you.
Your program has an outstanding reputation, and I'm delighted to hear that its services are expanding around the state.
Thank you.
The thing that concerns me is that, in a way, it's too bad that it's necessary to have this volunteer, privately funded through contributions program, as opposed to having something that our state government is able to afford to offer to all of our citizens.
Right.
We have
Agreed.
really a terrible two-tier system where wealthy people can afford legal services and poor people cannot, and so we rely on programs like yours and what the legal aid organizations do. But we also have this tremendous affluence within the state of Connecticut, and I'm wondering, do you foresee a day when, through charitable contributions, your program might expand to such a level that all the poor people who need it will get the service? It seems unlikely to me, but...
Well, that's my goal. I mean, that's always the goal of the Law Center, that we'll continue to grow until all the need is met.
So
Or
there-
that we can grow our alternative programs so that people are more collaborative rather than adversarial,
Right.
and so then they won't need the program either.
But in terms of the kind of mandate of this task force to come up with ideas for reforming legislation, other than your recommendations against the presumption of shared parenting, do you have some thoughts about modifying the existing GAL system in statute or in other ways?
I do. I think that I agree with the comments that were made about new GALs with little experience GALs need to be trained. There need to be better trainings. There need to be collegial organizations. One of the things that the Children's Law Center has done is created the Regional Academy of Child Advocates, so that once people graduate from the training that the judicial branch does, there are a group of professionals who can get together and talk about difficult cases or difficult issues that GALs confront. Mental health professionals also attend those, so that we can learn from each other, and GALs who may not have the experience that we'd like them to have can get that experience or that education. So continuing to educate and in some way oversee the role of the GAL can't be a bad thing. It can only result in GALs being better at their job and more efficient at their jobs.
Great, thank you.
I have a quick question. You talked about your FIT program, which is different than a guardian ad litem appointment. Is that right?
Oh, yes.
Okay.
It's completely different.
When your agency receives a guardian ad litem appointment, do the people also participate in the FIT program?
They don't, no. There are cases where we identify the parents as it's less of a custodial high conflict issue for court and more about them learning how to communicate with each other, and we'll recommend to them that they might want to sign up for the FIT program. So we do have those cases where we're a GAL in one case and they're also signed up for the FIT program in their separate case, but they're not automatic.
Okay. And do you attribute a good deal of your success in keeping people out of court to the FIT program, that type of intervention?
I wouldn't say too many of our cases are automatically sent to the FIT program, and they have to sit on a waiting list just like everyone else. So I wish I could say that was true. As it grows, it will be more true. But I think that the qualifications and the talents of the volunteers for the FIT program, our staff attorneys and our mental health professional also share and have and use those when they work with the parents in the GAL case as well.
So even if the parents aren't participating in a FIT program, they're reaping the benefits of that type of education, that type of approach?
Right.
And do you attribute your success to keeping people out of court to that approach, that collaboration?
I think so, yes.
Thank you.
Quick question.
Representative Gonzalez and then Dr. Thayer.
Yeah, I just wanted to make actually, Minnie, I just wanted to make a comment and offer that I would be more than happy to accompany you on your tour of the Children's Law Center.
Thank you. My question, a quick question. You still recruiting volunteers?
For the FIT program?
Mm-hmm.
Sure.
Okay.
We never stop recruiting volunteers.
Okay.
Sure, thank you.
I'll be there. Thank you.
And I have a question that deals with one of our charges and parents not complying with custody and visitation orders. What would you suggest the court do to help parents comply?
That's such a difficult question. Compliance is a huge, huge issue, and I've shared the frustration of many parents, and my GALs in my office have the frustration of a parent not complying and go to court. A motion for contempt may or may not be granted, but there's very little enforcement even when someone is found in contempt. I don't, however, agree to using time with the children as either a sword or a shield to those contempt motions, because that's using the child to punish a parent, and that only further puts the child in the middle of the conflict that we're trying to keep the children away from. So, fines, I don't have a problem with an incarceration for a set amount of time with a parent who's constantly violating court orders. I think it's a disrespect of the court and the system, and I think a short time of incarceration for a true violation, willful violation of a valid court order, might curtail that.
So with that being said, the follow-up to that is if it's the custodial parent that gets incarcerated, then that child or children go to the non-custodial parent. And then when that custodial parent is released, do you flip-flop that child back to the original custodial parent?
I don't know the answer to that. I mean, without knowing all of the circumstances, I can't say, depending on the amount of time the parent was spending in jail and how much time that child spends with the other parent. Otherwise, I couldn't say for certain that the child should go and come back. It could be a weekend. Oftentimes, I've seen courts order incarceration for the weekend that the children are with the other parent, so there is no disruption to the children's schedule. So I couldn't say. I couldn't say.
Thank you.
I think I'm done.
Thank you. I'm sorry. I'm distracted. I apologize. I think that we are all set, and thank you very much for your testimony, written and spoken.